I am Emily Greenwald. I'm moderating this session, and I will introduce it formally in just a minute since it's exactly 1:30 Mountain Time, 3:30 Eastern Time. I'm just going to give it a minute as people come in, and then we'll get started. While we're waiting, I'll tell you an amusing anecdote, maybe. I was appearing before an undergraduate history class yesterday in Teams, and I was introduced, and then I was suddenly speaking to a bunch of squares with people's initials in them, no real face after the introduction. And so I complained about it. And the students did turn on their cameras, or some of them did, which was much nicer than speaking to a bunch of squares with initials in them.
Yeah, I found that last term while teaching. It was I had to ask people. There's only 9 students in my class, and I had to ask them to turn their cameras off.
Yeah, it's hard to talk to just deadness. All right, so now I think I will get us started. Welcome to the, excuse me, great start already. At least I'm not freezing up. All right, welcome to the NCPH session, Historians and Indigenous Rights, the role of expert witness historians in litigation involving Indigenous land, water, and treaty rights in the US and Canada. This session is in a roundtable in which our panelists will discuss how they bring their expertise to bear on litigation over Indigenous rights, what drives such litigation, best practices for research in a litigation setting, and differences between Canada and the United States in court proceedings involving Indigenous rights. I'd like to introduce our 3 panelists, and then they will briefly give you a little background about themselves and how they came to be experts in this field. And then we'll start the process of roundtable discussion. If you have a question, please put it in the question and answer, and we will have about 30 minutes at the end of the session for questions. If something comes up during the course of the discussion that really seems relevant to what we're talking about, I will try to work it into the moment, but most likely we will leave most questions for the end of the session. All right, our panelists are Richard Hart, Ian Smith, and Jean-Pierre Morin. Richard Hart is an independent consulting historian who has served as an expert witness for Native American tribes, the US Department of Justice, and states for 50 years. In addition to his expert witness work, he has had a distinguished career as an author, director of nonprofits, and serving on boards and editorial boards. I want to particularly call your attention to his 2018 book, American Indian History on Trial, Historical Expertise in Tribal Litigation, which is completely on point for this session. I'm guessing that Richard is the only one here who has an archival collection named after him. In fact, the University of Utah holds 3 such collections containing Richard's papers, photographs, and audiovisual materials. When I asked him for a fact that others might not know, he said, he may not look like it, but he is a great-grandfather. Or maybe he does look like it. Jean-Pierre Morin is the departmental historian for the Departments of Crown Indigenous Relations and Northern Canada Affairs, Northern Affairs Canada, I want to get this right, and Indigenous Services Canada. He specializes in the history of government policy and administration of Indigenous and Northern affairs, as well as treaties. He is also an adjunct research professor for public history in the history department at Carleton University in Ottawa, Canada. He is the author of Solemn Words and Foundational Documents, an annotated discussion of Indigenous Crown treaties in Canada, 1752 to 1923, which teaches readers how to analyze and understand treaties as living documents. A little known fact about Jean-Pierre is that he had to teach a now former Prime Minister of Canada how to pronounce Michilimackinac, and the guy still got it wrong. I'm going to put the spelling, or Jean-Pierre is going to put the spelling in the chat box for people who aren't familiar with the word. Ian Smith is a principal historian, shareholder, and history division manager at Historical Research Associates. Ian has served as an expert witness for tribes, the United States, and other parties, focusing primarily on Native American issues and water rights. In a less typical expert witness engagement, Ian testified on behalf of the United States in a case involving a statue of Jesus on land leased from the Forest Service within a Montana ski resort. His work as a historical consultant covers a wide range of subjects, including mining, navigability, rights of way, and industrial history. He is the 2021 recipient of NCPH's Excellence in Consulting Award for his expert witness work relating to Native American land and water rights. What you may not know about Ian is that he plays keyboards for the band Cowboy Andy and the Salamanders, wearing a Prince-inspired cloud suit, which hopefully you are seeing a picture of now.
Wow, you did find it.
It looks awesome.
Very good.
All right, and I am your moderator, Emily Greenwald. I'm a principal historian, shareholder, and president of Historical Research Associates. I also work on expert witness. I also work as an expert witness on Native American issues, as well as contaminated sites, navigability, and rights of way. Outside of litigation, I have co-authored several administrative histories for the National Park Service. And what you may not know about me is that I wanted to follow in my aunt's footsteps and become a doctor for the Indian Health Service, which is how I got interested in Native American history in the first place. And then I ended up majoring in history and subsequently studying the history of federal Indian policy in graduate school. Also, this is only the second time I have put on a dress since the pandemic began. Same dress both times. So I'd like to start by asking each of the panelists to tell us a little bit about their career pathways and how they became an expert in Indigenous rights issues. Who would like to start? Richard, how about you start, since you were the first one to?
Sure. Well, about 50 years ago, in the late 1960s, a little over 50 years ago, I was working for the American West Center, whose director these days is Greg Smoke of NCPH. At that time, it was a fellow by the name of Floyd O'Neill, and he sent me down to Zuni one day, where they asked me a couple of questions very seriously. And I eventually said yes, I would do what they asked, and realized that it would take many years to finish that. It resulted in a claims case which began in 1968 for me and was settled in 1990. But that was the beginning of my career, and I've been with it ever since, for better or worse.
Jean-Pierre, how about you?
Sure. So I've been at the, this is a hard story to tell, but anyways, I have been working for the Canadian federal government as a public servant, as a historian, since 1999. This is the 22nd year that I've worked for the departments. It's always very confusing because, like in the US, we used to have one single federal department that was responsible for Indigenous affairs, similar to the Bureau of Indian Affairs. And in 2012, I got stuck with the job of splitting the departments. And now we have two departments, and it's a very long, complicated story, but nonetheless. I've been working at the department. I initially started in a unit that dealt with treaties that had been signed between the Crown or the Government of Canada or the British state, or the Canadian state, with Indigenous peoples, with First Nations, as we would say here. And over the years, I basically was brought in with very little experience in Indigenous history to start working on the history of that relationship and how that relationship has grown, how it's evolved, and how it's changed. And basically, it's meant trying to understand what Indigenous perspectives and Crown or government perspectives of treaties have been. And this has led me, that's why I wrote that book, because ultimately I realized that we weren't really clear as to how we should be interpreting treaties, because everybody always approaches it from this very monolithic kind of approach. Over the years, that task of writing the history of treaty making has spread, because you need to know the history of the broader history of Indigenous affairs to place treaties in its proper context. So I've become the departmental historian for all issues relating to the history of the department. And now we do hardcore deep dives into the history of program services and basically administration. And ultimately, I've become an expert that's used in court only because there's no one else. There is no one that's really an expert in the history of the administration of Indigenous affairs in Canada. It is that our Department of Justice turns to us and says, we need somebody to be able to explain why the department was the way it was. So therefore, I'm the one that's called on to go and do that. It's a very haphazard way to end up in front of the courts.
Ian, tell us your story.
Sure. Yeah. My name is Ian Smith, and I've been with HRA for 20 years now. But for the first probably 10 years of my work at HRA, I was kind of more behind the scenes working on a lot of these cases, some of which, and we'll probably talk about this more, some of these cases that we work on never get to trial, right? So there's never any expert witness work, but there's litigation support kind of behind the scenes. And I did a lot of work with, my former supervisor, Daniel Gallagher, who had, established relationships both with tribes and with the U.S. Department of Justice starting back in the early 1980s, and did a lot of work with him for the first 10 years of my career at HRA, while also going back to school and doing my master's work at the University of Montana, focusing on Native American history and environmental history with Dan Flores. I really started doing expert work 10 years ago. My first case was actually the Jesus statue case that Emily mentioned. But since then, I've done primarily expert witness work related to Native American water rights, land issues, rights of way, reservation boundary and diminishment cases, and one taxation case, which is kind of interesting. And with respect to the band, that's one of many bands that I've played in over the years. And I will say, on its face, there's probably not a lot of similarities, perhaps, between playing in a band and doing testimony, but I would actually argue that there is a kind of performative aspect to testimony that, that playing on a stage may actually help you with. So we can perhaps delve into that later.
Yeah, absolutely. I have some questions here that we'll spend the next 45 to 50 minutes talking about. And if the panelists happen to move naturally into new topics, I won't interrupt with a question, but then I'll try to stop it at about 2:30 Mountain, 4:30 Eastern, and open it up for questions. But feel free to go ahead and put your questions into the Q&A as they occur to you. So to start us off, if you would talk about some of the specific issues you've worked on in the field of Indigenous rights and what are the primary drivers behind such litigation. And as I'm sure will become apparent to the attendees, there are lots of differences between how these things work in the US and Canada. So let's also try to highlight those kinds of differences in terms of the issues that come up and why they come up. So who would like to start?
So I can begin. I've had cases dealing with, in the United States, recognition of a tribe, and in the United States, Congress has actually provided criteria or definitions for what a tribe is, which are essentially based on anthropological descriptions. In Canada, I recently did a case where the Canadian government had declared a tribe non-existent. So that I would think that is one step below acknowledgement. You got to first prove that they exist. I've also done reservation boundaries, like Ian, and submerged lands, like Emily and Ian both. They know some of those issues, I'm sure. And religious use and water rights.
Yeah. I'll go up. as I mentioned in my little intro there, a lot of the work that I've been asked to participate, a lot of the cases I've been asked to participate have dealt with administrative histories of the department, aspects that deal with explain to us why this group has been dispossessed, or explain to us why these lands have been taken, or why a band has been dissolved or created, or whatnot. And a point of terminology, because I have to stop. I'm going to do this right now. I'm going to continuously use the word crown throughout this session, because crown is the equivalent of the state in Canada. A crown prosecutor is the equivalent to a state prosecutor. So every time anything is ever done, it's always in the name of the crown, because Lizzie over there on the other side of the ocean. But at the same time, terms like tribe are not used in Canada in the same way. We use the term band or nation. We also use First Nation and not American Indian. So just to clarify that already from the start, there's an issue of terminology that makes a clear distinction, because it leads to smaller aggregates than larger aggregates than you will find in the United States in some cases. Other kinds of cases that I get brought into do deal with treaties, how treaties have been understood by the Crown. And often I've been brought in as a kind of friend to the court to come in and help explain the broader context of the issue, not always as like this is the expert witness for the Crown, but really to actually be like a friend of the court to answer a general set of questions, where I will get questions from the Crown lawyers, the First Nations lawyers, as well as the judge. Because in Canada, as we discussed earlier, the judge is a very active justice. Any justice is a very, very active member or participant in the court process itself. So it's varied. I'm always there to represent, or I'm always invited to participate by the government side. As a federal employee, I'm actually not allowed to be there on behalf of an Indigenous organization. So it's very specific as to who or as to why I can be there.
That's really interesting, Jean-Pierre. And just to put this out there, I've only worked in the US, not in Canada. But one of the things that's interesting about what you just said is that in the US, there is a thing called the federal trust responsibility. So a lot of times in the context of litigation, you will have, like, for example, in water rights cases, the US will either bring a case or align alongside a tribe within the context of a state-based water rights adjudication, which is a whole nother interesting topic in the US, that the federal government can be brought into state-based water rights adjudications. But a lot of the work that I've done, has been through that lens of the federal trust responsibility, right? So I've worked for the US Department of Justice on behalf of the tribes, as well as working directly with tribes, advocating for themselves on a variety of issues. And again, I've worked on water rights issues, a reservation boundary diminishment case that actually came about through a criminal proceeding, which is kind of interesting. Maybe we can talk about that too, as well as a rights-of-way issue involving an alleged right-of-way that a county claimed existed based on a map that showed a road that was never built. They claimed that it was still a valid right-of-way. So anyway.
So if I could just jump in for a second, I would, on the basis of what Jean-Pierre was talking about, I think it's really interesting to think of tribes like the Sinaiaks, who I've been working with, who had Aboriginal territory on both sides of the border. And on the Canadian side, First Nations can make political decisions that may affect various bands. And on the US side, they are basically anthropological decisions. The US people living on the US side may believe that they have to be defined as a tribe, whereas on the Canadian side, they can be, for political reasons, part of a First Nation that gives them more political clout. And these are on both sides, they're good reasons to to take either side. And so it's a very difficult thing for a collective that includes people on both sides of the border to make a decision on how to proceed.
Yeah, and this is the legal distinctions or the legal status of Indigenous communities in Canada versus the US are so radically different. For example, in Canada, Indigenous communities are only, well, sorry, I'm going to be extremely specific. First Nation communities, which are legally defined as Indians under legislation, are exclusively a federal jurisdiction. So any reserve lands, or as we would say in the US, a reservation, these lands are entirely administered by federal statutes and federal laws. The Indian Act, which is by far one of the most racist pieces of legislation in Western civilization, and that's actually, I'm actually not joking. It's a document created to racialize people, is a document that defines whether somebody is a group that we will recognize. If you meet the criteria and we do the research, it means that. And so long as a group is not legally recognized by the Act, they can't even bring legal proceedings against us because they can't get legal standing. So part of my job is often to work with the department and the Department of Justice in either trying to get groups to be recognized so that they can even start a proceeding against us, or to try and look at, is a group even part of, like, why would a group be excluded or included in part of the legislation? So that legal nuance means, like, issues about provincial, like the federal government would never side, the Canadian federal government would never side with a First Nation in a legal proceeding, unless it's about a constitutional challenge. That would be the only reason it would ever do it. So this idea that there's the federal government would take a case on behalf of an Indigenous group in Canada is unheard of on this side of the border.
Well, it's interesting too in the U.S. because obviously there's issues here too. In particular, I'm thinking of water rights adjudications, for example, which encompass an entire river basin, right? You have oftentimes more than one tribe within that river basin. The U.S. is in a position where it has a federal trust responsibility with more than one tribe within a river basin, and how does it deal with the conflicting nature of claims? For example, the Navajo Nation and the Hopis are both in the Little Colorado River Basin in Arizona. They both have very different perspectives on their own water rights, and the U.S. is trying to uphold its federal trust responsibility with respect to both tribes. How does it do that? It's a good question. So that's an interesting kind of example, I think. Another thing that I had noted as well is, political implications of the federal government's role or trust responsibility. We just had a change of administration here in the US from Trump to the Biden administration. And it makes me wonder about, how decisions get made with respect to what cases the feds might engage in or enter into, because they don't enter into all cases where tribes are bringing suits, and the positionality of the federal government with respect to tribes as administrations shift.
So one of the things I would add is that the Department of Justice in the United States, the real client is not really ever the tribe, it's really the Department of Interior. And so if there are other federal lands or resources that may be involved in the case, it oftentimes creates a conflict, which makes it very difficult for the attorneys to address. So it's not as simple as in Canada. There's no trust responsibility. In the United States there is. I mean, tribes oftentimes in the United States sue the United States for a breach of the trust responsibility.
So I would actually, that's a fascinating point. because in Canada, there's a legal construct. I'm going to call it a construct for lack of a better term, called the honor of the crown. And the honor of the crown is tied to two concepts. The first one is that the crown, the government, the state, the monarch is always supposed to be doing the best thing. So any actions of the crown have to be about how the government of Canada is doing the right thing. So how we are supposed to be dealing with an Indigenous issue in front of the courts is supposed to be based in this context of the honor of the crown. The other half of it is that the government of Canada has a constitutional fiduciary responsibility towards Indigenous peoples under the Constitution. In 1867, when Canada was created, a specific clause of the Constitution stated that the federal government was responsible for Indians and lands reserved for Indians. This is where all federal authority flows from. So that is what creates this fiduciary responsibility. But at the same time, we found all kinds of ways around it by violating it in all kinds of different ways. But at the same time, the Canadian Constitution was repatriated in 1982, where we basically rewrote the Constitution. Britain gave it back to us. And Canada inserted, at the insistence of Indigenous peoples, that we include the protection, the recognition and enshrinement of Indigenous rights and treaty rights into the Canadian Constitution. So almost every single Indigenous court case is constitutional. It's a constitutional issue, which I know is not the case in the US.
That's a really interesting difference, and it makes me think, what might we do if we could rewrite the US Constitution at this stage and make it a little bit, I guess, more adapted to the present situation. Let me pose another question to you all, which is I think you've talked a bit about what you do as an expert in litigation, but you could talk a little bit more about how your role is given, how your expertise is given weight by the courts as compared to Indigenous traditional knowledge or historical documents, and how these different ways of, I guess, bringing opinion and evidence to bear on legal issues are handled by the courts in the US and Canada.
Well, I think first of all, to understand, it's important to understand what an expert is. Normally, witnesses are allowed to testify about firsthand knowledge. Well, I saw the car wreck, and this is who ran the stop sign. An expert, on the basis of qualifications, usually a court is going to qualify the expert, can examine secondhand evidence and make an opinion about that. So in our case, it's on the basis of oftentimes a lot of historical documents, and we can read the documents and reach an opinion. Now, in the United States, I think it's more difficult for a Native American, for a tribal member to testify. They rarely get expert status. And I think it's a little easier, Jean-Pierre can speak to that, I'm sure, a little easier in Canada for traditional leaders to testify. There are some exceptions. During the Indian Claims Commission, one exception was made for traditional knowledge about boundaries. And there are a few other exceptions. But so an expert, even if you're an expert in one subject, it doesn't mean you can have expert opinions on other disciplines. And you still have to have a basis for your conclusions. So it's important to be objective more than anything else. I think as an expert, it's important to not be an advocate. The attorneys are advocates, and that's their role. And witnesses have to be objective. And I do think, I think from what Jean-Pierre said, in the case that I was in Canada, the judge was much more active in asking questions than in any federal court that I've been in the United States. And in fact, the judge in the case I was in actually took over essentially and asked really well thought out questions of the witnesses, and reached a great decision, was very well read and very well prepared for the case. I mean, I think in the United States, federal judges, in my opinion, have been well prepared for the cases too. But in Canada, the justices seem to be much more active in the courtroom.
And Jean-Pierre, did you want to comment on the?
Well, I think I let you go first, and then I'll
Okay.
wrap up because I have some. I want to tie in a few things with my statement.
Sure. Yeah. Well, first, I think I would start by underscoring what Richard said about the importance of trying to achieve objectivity, or at least the importance of doing really deep dive research and basing your opinions on that. And we might be getting ahead of ourselves a little bit with some of the questions here, but that I can't underscore the importance of that enough. But on the question that Emily posed, about traditional knowledge, I'm a non-native person, and one of the things that I know Emily and I are talking about is, as a company at HRA, we're trying to think about ways in which we as a company might be able to, facilitate or help Indigenous scholars have a pathway into this type of work, as expert witnesses, where that, as Richard said, that often has not been the case, at least in the United States. We're thinking about, perhaps scholarships, internships, that type of thing. So I guess I would maybe leave it at that and let you fire away, Jean-Pierre.
Sure, thanks. One of the things that's interesting is that we're all going to say the same thing, is this point that as an expert, we're still supposed to be objective. We're supposed to be providing our best opinion and our best analysis of the research that we've done and how we present it, either in the factums that we're going to write or the affidavits. I'm assuming these things are relatively the same in the US, or the actual testimony that we provide, right? So I often end up with lawyers that ask me to come and be expert witness as an expert witness become very unhappy with me, because I often am very critical of the legal position that they are putting forward. So I spend a fair amount of time picking apart their legal argument, because their legal arguments aren't based in historical reality. On the one side. The other side is that often I'm asked as an expert to comment on the testimony of somebody else. For example, Richard or Ian would be brought in by a First Nation, and I would be asked to comment on it. And then that becomes part of my role as an expert. And often I can't find fault, because it's not about fault, because we're all trying to be as objective and impartial and present the best possible arguments available. So this is one of the weird realities of myself being a non-Indigenous historian who's hired by the Canadian government, or used by the Canadian government, because I'm already hired by them, to represent them, where they know that I may criticize them on the stand. And this is one of I make that very, very clear before I actually start any process with them. I'm like, I may disagree with you, and I will have no problems doing it on the stand if you so push me in the wrong direction. I have been treated as a hostile witness by the government of Canada in the past, when I was their own expert. So part of this is that they often want historians like myself to criticize and to comment on Indigenous oral histories that are being presented in the courts. Because in Canada, there is massive jurisprudence that brings oral histories, Indigenous oral traditions, Indigenous oral perspectives to the same level as all other forms of evidence. There are several court decisions dating back from the 60s and 70s, Vanderpeet as an example, but the most important one is the Delgamuukw decision, which basically stated that oral evidence is identical to any other form. You have to treat it like any other element. This idea that somebody, if you haven't seen it, you can't report on it, you can't comment on it, that's not a reality. An elder arriving in the courtroom to present evidence is an elder providing evidence. It is treated as any other expert would. And then my job is to try and see how it corroborates or how it lines up with the historical record, the actual archival record. And are there consistencies? Are there inconsistencies? Is there a problem? And that's the kind of work that I would actually do. So it's a little bit of a mishmash. It's a very different approach to what I have to do than what Richard and Ian have to do. But at the same time, it's always about this idea, in my opinion, of making sure that the information we're providing is not actually here to support a court case. It's here to provide the best possible historical analysis.
Maybe you guys could elaborate a little bit more on this point of what you do when the historical evidence maybe does not correlate well with the traditional knowledge being presented, or perhaps if it's not being presented in court, the traditional knowledge on the subject that you're dealing with, because I think those situations do come up. And as historians, our expertise is in reading primarily written records and putting a lot of trust in them as sources of evidence. So what do you do when oral tradition and written record are in conflict with each other or don't completely line up?
I think analysis is really important. I mean, that's one of the things an expert does. And so in the case of, in both countries, you had a colonial oppression of the native peoples. And so there may be a very different story that's told by the colonial power than is told by the traditional oral tradition. And so as an expert, one of the jobs we have is to explain why these differences occur. But I think my impression has been in court that in terms of oral tradition, it's best to find some kind of corroboration if possible. And I was just going back a little bit, I would say it's pretty interesting in the United States to find a religious leader classified, a traditional religious leader from a tribe classified as a lay witness, which happens fairly frequently. But corroboration, analysis and corroboration are the two important issues that I would see as an expert.
True too. I think that's true too with respect to the written record as well, right? Because oftentimes you're not going to always, the written record itself is not going to be, 100% one story. There's going to be discrepancies there too. So I would just underscore what Richard said with respect to the importance of analyzing the entirety of the body of evidence, whether that's written, oral, if it's, perhaps testimony or evidence that was provided to an anthropologist, 100 years ago or something like that. The extent to which you can look at the evidence in its entirety and come to a reasonable conclusion. There's always going to be, a shred of evidence here or a shred of evidence there that's not going to necessarily align with your analysis. But it's really important to be able to look at that whole picture and come to a reasonable conclusion that you are comfortable with and willing to, I don't know if defend is the right word but yeah, defend, I suppose.
History is never as clean as it should be. There's always anomalous evidence. And an example or an illustration I've heard mentioned before is if there's a car wreck at an intersection and you have people standing on every corner, you might have 13 people saying the red car ran the stop sign and hit the blue car, but you may have one person that blames it on the blue car. There's always a piece of anomalous evidence. And as an expert, that's one of the jobs we have, is to try and figure out how you explain it. Also, I would say in court, a very important thing is to be able to, I think one of the questions we often get asked is, could two different historians look at the same evidence and come to different conclusions? And if an error is pointed out, we have to be able to say, yes, I think I was in error about that.
Yeah, and those are extremely, like, those comments all resonate with me immensely, because ultimately our jobs are to ensure that we understand the authenticity and the veracity of the documents and the sources. I should use the word source instead of documents, because documents is a colonialist structure. The sources of this information or this data that we're looking at, we don't necessarily treat it the same way. An oral testimony can't be treated the same way, because it's much more contextual than, say, a document written by a government official 150 years ago. That oral testimony is alive, for lack of a better term, and is constantly changing with the interpretation of the people who are presenting, who are sharing that knowledge. And ultimately, that's actually one of the aspects. This is a sharing of knowledge. This oral evidence, for oral tradition, this oral history that people are sharing is literally the sharing of community knowledge in a manner that is acceptable to the court. And we as historians, and I'm kind of stepping aside from the answer here to philosophize a bit, we need to understand that that's just as valid and just as acceptable as any other piece of archival documentation that we may find. In Canada, we also have the courts who keep playing with how we are to do things. There has been massive amounts of jurisprudence, as I mentioned, and we actually have one Supreme Court decision, our version, or our Marshall decision, as it's called, from 1999, where one of the dissenting judges actually made a 9-point list of how we should interpret treaties, those treaties signed between the Crown and Indigenous peoples. And part of that is an underlying legal concept that when there is ambiguity, we should be erring on the side of Indigenous interpretation instead of the settler states interpretation. And that means that when we hear oral traditions, oral histories that don't work in quotes with our traditional perspective, we need to stop and reframe our question in theory. This is what we are supposed to be doing. I have found in my experience that Crown lawyers don't really want that in some cases. Those that do are a rare breed, but mostly my job is often pushing back against the lawyers, saying you can't interpret that oral history in that way. You may think it works for your legal argument, but you're in violation of the spirit and intent of how that was shared in the first place. So I'm not trying to make myself sound like a more moralistic person than I am. I don't necessarily always agree with the legal positions that the government of Canada is taking. And I see it as my job as a public servant, as a historian, and as a good citizen to try and find reconciliation with how we should be solving these issues. Earlier, I think, Ian, you had mentioned that the change of administration changes the kind of court cases that you take. Well, in theory, the same thing happens here, but it actually doesn't. Because in reality, the current government announced changes in 2015 as to how we would proceed with Indigenous legal cases, but in reality, we haven't. So how we actually do that from a policy perspective, to a historical research perspective, to a judicial perspective, are always in conflict. And I'm often caught in the middle, because I also work on the policy side. Being a historian and an expert witness in court is actually the smallest part of my job, because I do all kinds of other aspects, and this gets thrown into the mix just for fun.
I think if I could just add one thing from the US side, I think it's a well accepted fact that in the analysis of treaties, you have to take the position of the tribes as they understood it. And the reason is that they were at a disadvantage. They were usually not literate, and it was all in a language that was unfamiliar to them. And so you have to try and understand the treaty from their perspective at the time.
It's called the canons of construction here in the US, but the extent to which it gets applied, I think, is, questionable at times, especially by entities or parties in litigation that are opposed to tribal interests. They're going to push the opposite viewpoint to the extent fathomable, even beyond fathomable, perhaps in certain instances.
Right.
Why don't we jump to another question? I think, although Ian touched on the issue of being a non-native person working as an expert here, might see if we can come back to that a little later and talk a little bit more about the best practices that you can recommend for people working on working in litigation as experts. I know there are probably some that are unique to working in the field of Indigenous rights, so we should probably highlight those, but a lot of it is translatable to other types of issues you might be working on as an expert in litigation.
Well, I'm sure, Emily and Ian, I know that you have been confronted with situations where an attorney will call up and say, can you find evidence to support the following conclusion? And that's the wrong kind of question.
That's right.
That's the question. Is it true or is it untrue? Is the following true or untrue? Is there evidence to support it or evidence that doesn't support it? So it starts right from the beginning, from the first time you're asked to start the work. And there have been many times when I've said, no, I won't take a case like that. I won't take a job like that. Or there have been times when even after a preliminary look, I call up the attorney or the tribe and tell them, I'm sorry, but I don't think the evidence supports your position. So I think that's a good place to start. And then I know one of your other questions, Emily, has been, how do you gain trust from a tribe? And I think that's one of the things that you have to do. You have to be able to tell them the truth. Sometimes tribes are people too. I mean, they're just human beings. And sometimes they're right and sometimes they're wrong.
Yeah, I think that's a really important point that I noted in my notes here, is that you should not ever, if you're finding evidence as you're doing your research that is contrary to the legal position or the argument that the attorney or attorneys that you're working with are planning to make, it's never helpful to hide that from them. It is always important to let them know about that as soon as possible, right? Because the last thing you want to do as an expert, or you want to put the attorneys with whom you're working in this kind of situation, is to have the other side, throw a document at you, Perry Mason style, say, what do you think about this, Mr. Smith? So the sooner that you can get potentially contrary evidence out in front of the attorneys with whom you're working, the better. And they may be able to, shift their legal perspective. It may enlighten things. It may not torpedo their case, right? But it certainly should inform the way they're going to move forward.
Right, and similarly, I think, there is, as I said, there's always anomalous evidence. And so it's better that you present it than the other side presents it. So it's better if you have contradictory evidence, it's better that it's presented up front than just letting one side present positive evidence and the other side present negative evidence.
Right.
Yeah, I completely agree. And I think to build on that, one of the core practices that I've adopted is that I ask way more questions than the lawyers ever want me to ask while we're trying to figure out what the research question that they want me to answer, right? As Richard said, they arrive and they find me this, and it's like, well, what do you actually mean? What kind of thing are you looking for? Why? Like, they never tell you the why they want it, but you know, it's like, what's the parameter, what's the context of what it is? Because ultimately I have found that if I don't ask those questions, I tend to go down a path that doesn't respond to what they're looking for. Regardless, it's like you end up in a completely wrong topic, which is a major waste of time for everybody. But also you can make conclusions about something that is not necessarily related. So then they make conclusions about the research that leads them down the wrong path. So I always want to make sure that I have a very clear understanding of what they want from me. What the parameters are, I'm not sure what the nature is of how when you sit down, but we usually have a laundry list of questions that must be answered. And then that's what leads to the research report, right? And then we come back and we answer the questions. At this point of making sure that you tell them when your evidence is not going to prove it to them, is not going to support their case. We just did this last year. We had, it's a major constitutional challenge. It is a huge case. It is going to be very expensive. And they asked me to write a research report expecting a result. And we pointed out to them from the start that that's not likely going to be the case. We knew that wasn't going to answer the question, but they asked us to do it anyways. We did it. And then when we wrote and gave them the final report, they went, well, we're going to omit these parts of your report. And I went, under no circumstance will I sign an affidavit if you exclude this from the report, because now you're misleading the court. And that's another best practice, which is stick to your guns.
Right.
Do not let yourself be intimidated by a lawyer who wants to make a case which could jeopardize your career.
Yes, I'm going to echo that you really want to be careful about your own integrity as an expert. And fortunately, I've only had one situation come up that really troubled me on that front, where I felt that an attorney was pushing me to go in a direction that I didn't think was well supported by the evidence. Most of the times, attorneys have been completely reasonable. And I would just say about that attorney expert relationship, keep in mind that you're dealing with someone who is, the attorney is very smart and may know a thing or two about history already, but definitely knows a thing or two about the law and the standards of evidence for the issue that you're dealing with. And so you need to listen to that and not be thinking that I'm the only one who is an expert here. I have the knowledge. Let me teach you. So you know how. Put your ego to bed sometimes, and don't think you're smarter than an attorney. You're just smarter about different things, and use that knowledge, that expertise you have to help educate the attorney about the implausibility of the things that they may be expecting, or if they are talking about the history and the tribe in a way that you think is not very enlightened, that may damage their relationship with the people who are their clients, or if the Indigenous people are on the other side of the issue. You know, think about how they need to be using the right language and the right concepts that you have learned in your field to be respectful. So yeah, sorry to interject.
I agree completely with that. And I think that on the one hand, it's really important as a historian never to make legal conclusions. The court or the opposing attorneys will take you up on that and take you apart on that if you try and make legal conclusions. But on the other hand, it's important to understand a little bit, at least, of the law, so that you can frame the evidence the way it needs to be framed. And I think Emily and Ian, in particular, at least on the US side, understand how submerged lands and navigability, how important it is to frame the evidence in a way that the judge will understand it.
Absolutely. Yeah, I mean, I was going to say the same thing, that while we do have to toe this line of being historical experts and not providing legal conclusions or things that could be construed as legal conclusions. It is important, I think, to understand on some level the legal jurisprudence around the case that you're working on, both because, I mean, I think it helps you serve your client better as well. So yeah, I mean, another example, I think, Richard, that in the Coeur d'Alene case that you and I worked on together, I think the example of within the water rights context, not only establishing priority dates, but also establishing the purposes for which a reservation was created. Right. It's really, really important. And, you know, a lot of times in the case of Coeur d'Alene and many other tribes, that reservation and many other reservations in the US were set aside by executive order, that simply the executive order will oftentimes just say, set aside these lands, period. Well, that doesn't say a lot about the intent or the purpose for the establishment of the reservation. There's a lot of documentation leading up to those events and surrounding that you know, that you can contextualize that and opine on. But if you don't understand the relevance of the question regarding not only priority date, but also the purpose for the creation of a reservation within a water rights context, you may not be serving your client very well.
Right.
We're almost at the point where we're going to open it up to audience questions, and a couple of questions have come up in the queue. Please feel free to add others. But as we make this transition, I'd like to ask the panelists to tell us a little bit about what you like best about working as an expert in the field of Indigenous rights and what you like the least.
I would just say, I would start off by saying, you know, this is work that often it makes a real world difference, right? In one of the cases that I recently worked on, one of the ones for which I won the NCPH award for, involved a small, you know, relatively small parcel of land, but at a broader level, it was about sovereignty and this particular tribe's rights to, you know, maintain its sovereignty with respect to the county and the non-native developer who was trying to bulldoze a road across their land. In terms of, so I think that's like one of the primary things that I think is really great about this work. A couple of the more difficult things. One is that court deadlines are real and not uncommonly unrealistic. So that's kind of hard. And then another one is that I've often likened expert testimony and expert report writing to peer review on steroids, because I think, as Jean-Pierre mentioned, most of the time in an expert context, you are going to be submitting a report that's going to be reviewed not only by the other side's attorneys, but oftentimes by another expert historian, who's going to be looking at everything you cited, every you know, document or other piece of evidence you used. And yeah, you don't want to make mistakes, which can be yeah, difficult.
So I would, when I initially heard your question, I would have responded, the things I liked best about working with tribes in the beginning was probably going out in the field, being with elders, and getting out in remote locations with elders. It was really enjoyable for me when I was younger. I think today, after a lot of years and decades doing this, I would say clearly the judgments make a difference. I mean, I've been involved in cases now that have resulted in over $1 billion in judgments for tribes, but that's not a good way to judge the work you've done. The money is not a good way. I think some of the most rewarding cases of mine have been cases where the tribe didn't care about money or didn't care about a reward or a judgment. What they really cared about was confirming their traditional knowledge to see if it was true what the elders were saying to them, seeing if their story was correct and the United States story was incorrect. And in regard to what is most difficult or what I don't like about it, at my age, it's kind of hard to disengage. Yeah, retirement is a difficult question.
Jean-Pierre, how about you?
Oh, sure. So for me, it's a little bit different because I don't. It's really very much a side job for me, right? It's often off the corner of my desk. It's something that I end up doing on. It's work that I have to do on top of my regular work, so it's often done on the corner of my desk. So to me, that's a little bit of a negative, especially tied in with those time constraints that Ian just mentioned. While we were talking, I got an email in where I was asked to review 797 documents by end of day. That's in 30 minutes, which isn't going to happen. It's not going to happen. They can wait. But at the same time, these pressures are also fantastic opportunities, because part of my real job is to write the administrative history of my institution, of my department, which has never really been done. And every time I get to work on a court case, I get to refine a different element of that history. So to me, it's this rare opportunity, because most of us who work in litigation, this is gray literature. We don't get to use it other than in this legal context. And I have the very fortunate role of I can take I can take most of it and use it in a different context to help build out that bigger history of the department, which I will point out the Department of Justice constantly wants me to stop doing because it keeps making Canada look bad. As I always point out, that's not a hard thing to do when it comes to Indigenous peoples and Indigenous relations. We've done it ourselves. It's just about clearing the mud off of the evidence. But ultimately, those are those two things. To me, I love the debates that I do have with the lawyers, while at the same time I hate the debates that I have with the lawyers. Because when you can get one of those lawyers that are like, let me actually understand the issue that's happening. They want to understand, and often you can get them to change their argument. And in my case, it's usually always trying to get them to not prosecute in a specific way that will make it worse for Canada. Because ultimately, almost every court case that I'm involved in, we lose. Because Canada loses most of its court cases with respect to Indigenous peoples, because that's the nature of our jurisprudence, and it's always about defending the indefensible. So if I can modify that in some way so that we're not making this more difficult for communities, well, all the best. If I can get somebody to stop arguing a specific way, then my day is done and I can sleep well that night.
And I'll add my 2 cents again. One of the things that I find really engaging about this work is that you learn new things all the time. In the US, Indigenous experience and history is so particular to the community, the region, the location. And so even though you're being called upon for your broad knowledge, your general knowledge in a lot of ways, you still have to get down into these very specific histories, and they're all so different. It's just fascinating, and teaches us a lesson that we should be careful about generalizing about
Right.
experience and about the impacts of federal policy, which is an area where I've worked a lot. The thing that for me that has been hard is that I have generally worked opposite tribes, and I sometimes feel like I'm championing a position that is going to be harmful to Indigenous rights. And while I think I can practice my craft as a historian ethically and appropriately, sometimes it's pointing toward an outcome that is not beneficial for the tribes, and that sits on my shoulders. So it can be a little hard to live with. So let us move on to questions. We've had a few come in, and can everybody see the questions on FeedLoop, or are we just seeing them through the Q&A? on
They,
Zoom?
so yes, the questions are both in feed loop and in the Zoom. So what we have in the Zoom Q&A is what people are asking there.
So people can see that as well. I'm going to just hold off on the first question about Ian's consulting award, leave that for a little bit. But the second question asking, in America, how do your clients find you? Is it through website, court documents? And that question also asks, how did each of you find the specialty, which I think we went over at the beginning of the session, but if you want to say anything more about that, please do. So the main question is, how do your clients find you?
For HRA, I mean, I definitely benefited from HRA's kind of presence in the field. The company's been around since 1974, and we as a company started working on, I mean, I think our first cases involving Indigenous rights were water rights cases with the US Department of Justice in the early 80s down in New Mexico, I think. And that kind of branched out. So it's a lot of word of mouth, I would say. I mean, it's doing the work, hopefully doing good enough work that the attorneys like your work and call you back, and then that you you hopefully expand that network of folks who keep calling. I mean, one of the tough things with attorneys is that a lot of them, especially in governments, whether tribal governments or the federal government, aren't really that active on social media, I've found. So like you're not necessarily gonna I don't know, find them on Twitter or LinkedIn or maybe LinkedIn. And as you develop, you develop friendships with folks with whom you work, and you might have Facebook friends who are your clients, which is true, but that develops over time. So a lot of it's been word of mouth, I think, for me at least, and HRA in particular.
Yeah, for me too, I would say almost all of it has been word of mouth. The tribes and their attorneys do pay attention to other cases, and when, in my case, after the Zuni claims case ended positively for the tribe, other tribes asked me to do similar cases. So, in fact, all of my work in my whole career has been unsolicited. In all the cases, the tribe has come to me. And the very first time that the tribe asked me to do work was Zuni, as I mentioned at the outset of this panel. And in that case, it was on the basis of my publications that I'd already done. So I think attorneys and tribes pay attention to publications, and they pay attention to the outcomes of cases.
Yeah, I'd say some people have also found me through, since I published a book way back when in 2002, some people have found me that way as well. There's a question about the Bears Ears litigation that I don't know if anybody on the panel has enough information to answer. A question about the litigation opposing the change, the rollback of designation of lands as Bears Ears National Monument. And I can't recall right now if that was a complete rollback of the whole monument or if it was just changing the boundaries. I recall that there was litigation. I would guess that the Biden administration is making a determination about how to resolve the issue by just returning to the original monument designation, but I'm not entirely sure. Does anybody know anything more about that one?
That's my understanding too, Emily, is that I think the Biden administration is taking under consideration possibilities to expand the Bears Ears National Monument back to its original size. I don't think anything's been decided yet, but on the point of of changes in administration. We've already seen some solicitors' opinions, for example, come out that reversed some Trump era actions with respect to lands with the Mashpee Wampanoag, as well as a recent solicitor's opinion involving the Mandan, Hidatsa, and Arikara tribes in North Dakota. So I think that, yeah, there is definitely an impact to changes in administration and how the U.S. positions itself. I often have wondered, I don't know if folks have heard about the McGirt case. It was a Supreme Court case. I didn't work on it, but the ruling came down last July, but the U.S. was actually aligned with the state of Oklahoma against the Muskogee Creek Nation. And I've often wondered, you know, if that case came up during a different administration, what the positionality of the U.S. might have been. It's kind of a hypothetical, but.
Okay, there's another question asking about how you decide whether to accept a pro bono project versus a paid or assigned project. Have any of you done pro bono work and can speak to this question?
Yeah, I had one case that didn't start out as pro bono, but it ended as pro bono. And I had another case that was entirely pro bono. I think that in order for me to take a pro bono case, the client would have to demonstrate to me that they really couldn't afford it, because I probably wouldn't want to take a case that wasn't pretty important to them. But the importance of the case, in my case, almost in every case I've worked for a tribe, they have thought they were getting a good deal, and usually the judgment they got in return was way more than the amount they paid me.
I can say that technically speaking, every single time it's pro bono for me, because the contrary to be an outside expert, the government of Canada doesn't give me more money. It's my regular plain old salary. So as I said before, it's my actual job to do this when required or when requested. So to me, every single time is pro bono, and it's actually, it's going to sound ridiculous, but it's actually becoming a problem because the cost, as we all know, the cost of hiring an expert can be extremely expensive. Tens of thousands of dollars for a contract, depending on the size of it. So using inside experts, even though it's not necessarily the Crown lawyers or state lawyers tend not to like to use inside experts because there's the idea that they may be biased. The fact that I have clearly demonstrated that I openly throw them under the bus has led them to want to use me more frequently. And that's actually a fairly unique kind of situation, because ultimately, if it plays, in my opinion, it actually places Indigenous communities at a disadvantage because they have to cough up money to pay for an expert while the Crown doesn't. And to me, this is Emily, you were talking about the moral responsibility, and I share the same ones as you do when it comes to like, we're representing, are we actually working for, like, how is this going to negatively impact Indigenous communities? But for me, this is the same thing. The government of Canada is using my services for free, and that means they have more money to hire more experts because I don't cost anything. So to me, that's always it's a part of my moral dilemma about agreeing to be an expert witness.
One thing that might be worth pointing out is that in the US, tribes have the opportunity to apply for litigation funds through the Bureau of Indian Affairs. So if they have, I think if they have a legitimate claim, they do have a route toward getting funds to support the hiring of attorneys and experts for that. If they're in a situation, so that's where they might be suing the US or something else where the US is likely the adversary, but when it's or when they need their own representation in addition to that being provided by the US in its trustee role. If the US is acting as the trustee and bringing the litigation on behalf of the tribe, then that defense should be being covered through federal funding as well. Ian, does that accord with your understanding? Oh, sorry, Richard, did you want to?
I was just going to say, I had one case where the government determined that the tribe was, quote, indigent. I won't name the tribe because they were very much opposed to being called indigent. However, it did mean that they were given litigation funds to sue the United States. And if they won, they had to pay back the United States. And if they lost, the funds were forgiven, the loan was forgiven. And it put the tribe in a position of taking money from the United States to pay for litigation against the United States. So, yeah, which really made the Bureau of Indian Affairs pretty angry.
That is quite interesting. I mean, I think to your point, Emily, there is both the self-governing and self-governance compacts and self-determination compacts, I think, are means by which tribes can get, in the US at least, can get funding to help support their own legal claims. And I don't think that it's limited to situations. I mean, I don't know for certain, but I don't believe it's limited to situations where the tribes are suing the US. Because I'm fairly sure that some tribes have been able to access that kind of funding in water rights cases where the US is involved as well. But I think I might have mentioned this previously, but oftentimes, or maybe Richard did too, but oftentimes the claims being brought forth by a tribe within the context of water rights are different than the US, right? So that the tribe might be claiming, for example, a priority date that's even earlier, or, a time immemorial claim that the US isn't willing to make. So it's very much, a valid situation for the tribe to be able to bring its own claims forward within a legal context, even if this is on the same side.
Yeah.
Sometimes the tribes have to intervene to be on their own side.
Next question asks, when you're on the stand or being deposed, how do you avoid the lawyer, I guess the opposing lawyer, tripping you up and getting you to say something seemingly at odds with your expert report, which is exactly what they're trying to do.
Right. Deep breathing exercises. Well, no, seriously. I mean, that's true. That also kind of speaks to a point that I had noted on my notes here that we didn't really talk about, is the differences between deposition testimony and trial testimony, where in a deposition setting, you are really at the mercy of the other side's attorneys, and you don't really have an opportunity to forth your own story. You're basically just being questioned by the other side, and really the judge isn't there. Your own attorney can object to questions, but you basically have to ask or answer whatever is asked of you in a deposition setting. In a trial setting, it's a little different because you are in a courtroom, you're on the stand, there's a judge there to kind of stop any untoward action that might occur, but you also have an opportunity to put forth your own side of the case. Oftentimes that's kind of scripted with your attorney, and then you have to be subjected to cross-examination and whatnot, where things can get a little more squirrely. But in terms of the question that I think Michael asked, yeah, I mean, The things I do are, one, prepare. Like, know the stuff inside and out as much as you possibly can. I also try to think about, always as I'm reviewing and analyzing and even researching documents, I try to think about what I'm looking at from the perspective of the other side. Like, how would they look at this? And then in anticipation of giving testimony, I do try to think about, what types of questions they're going to ask, and try to prepare, at least mentally, for how to respond to those questions.
I think that it's part of that is you need to be prepared.
Yeah.
Right. You need to study the material that you are going to be discussing. And I think I'm going to use the word discussing quite purposefully, because although it's not a discussion, right? You are presenting, somebody asks you a question, you have to stay within the confines of the question. And one of the things that I found quite fascinating is that if you start to stray out of the answer, away from the question that you've been asked, you'll be pulled back. And as a historian, we're all about, well, no, there's more context. It's more than this simple question. So you have to keep your answer in mind to the fact that you are limited in how you can answer it. So you need to always be prepared that the question asked is actually might be something else, might be about something else. And they're actually trying to get you to admit to something, right? As Emily just said, they're trying to trip you up. On a point that Ian just made, Canada doesn't have depositions the same way that you do. We have what's called discovery, and it does not involve the experts. We do not go. We write a report. We write a statement where we talk about what we will be talking about, and that's it. And you attach your CV, your credentials, and whatnot, and that's what it goes forward. So the first time that I ever interact with the litigators is in the courtroom, and that's where it becomes very interesting, because you're prepared on what limited information there is in discovery. So in deposition, you get far more information as to the kinds of questions that you may get, while I get none of that. And of course, as we mentioned earlier, one of the major differences is that when the judge starts asking you questions, when the justice starts asking you a question, you're completely thrown off, because those questions are rarely constrained questions, where your lawyer is asking you a question, or the First Nations lawyer is asking you questions. It's like a tunnel. You need to answer it in a specific way. But when the judge starts asking you a question, it can go anywhere. And those are the contextual questions that can throw you off. And you get asked these questions, they last 10, 20 minutes. And then you have to go back to the question that the lawyers are asking, which are 20 minutes ago in a completely different setting, and you're completely off your game. So it's the point that Ian made, that you need to breathe, you need to be calm, but you need to be ready to roll with the punches, whatever way it comes. And that comes from being as prepared. For those who have done a dissertation, it's the equivalent of prepping for your oral exams. You sit there and you spend 2-3 days reviewing all of the material, at least, so that when you are asked a question, you can answer the question in a manner that is understandable to the court.
I would add that the best insurance, of course, is to know your position, to not be trying to twist anything, and to not be trying to push anything into an advocacy position. That can be your insurance. I mean, I think in any fairly good sized case, you're going to have a lot of time to think about what questions you're going to be asked. In what Ian was saying about depositions, I know that I've been asked by tribal attorneys before to quit being so expansive and educating the other side. But you don't ever get that in court. It's fine to educate them in court because the judge is there, but it's not in a deposition. You're not there to educate the opposition. And I think also in getting, how does one protect oneself during cross-examination, during trial? I think there shouldn't be any surprises. You should have thought of all the questions that they're going to ask you.
That is one place where being deposed beforehand gives you an idea of where the other side is going with stuff, and they should be providing all of their trial exhibits in advance of actual trial testimony. So that you should be able, there shouldn't be any surprises in terms of documents. In deposition, you might be surprised with something that you haven't seen before, because face it, the historical record is huge and you can't possibly have laid eyes on all of the potentially relevant documents. And you might get asked, why didn't you find this? Why didn't you go do research here, as a way of trying to undermine your expertise or your opinion. So a couple of things that I would say are just answer the question in deposition, don't go on a tangent. And if they put a document in front of you, ask for time to read it. That time that you are reading the document does not show up in the transcript. So nobody knows if it takes you 5 minutes or 15 minutes. So take your time and read it and think about how it actually, you know, what they're trying to get you to admit about the document. Well, maybe there's more to it than that. Maybe there's a lot of gray area in that document that you can find if you don't just read the highlighted section that they have put in front of you, but really take the opportunity to carefully read the whole document.
That's a really good point, and I think that a good question to ask when you're provided a document like is to say, is this the complete document? I've been handed a piece of a document before that is completely out of context from the whole document.
I got handed a piece similar to that. It was an excerpt of a document, and they asked me to comment on it, and I asked them if they had the rest of the document for me to review, and they didn't. And I asked them if I could provide it to them because I had it on me as my person. It was in my pocket, and then they went, "How did you have that?" I'm like, it's my job to be ready.
Before we finish up here, I'd just like to go back to the first question that came in, because this is something that I had mentioned earlier on, that I'd like Ian to just talk briefly about how you got the Excellence in Consulting Award for being an expert witness, since I think that's not a typical thing. I don't know if it has been awarded that way before, and there may have been some confidential materials involved with applying for it. I don't know, but if you could say a little bit more about what case that was and how you went about submitting materials to be considered for the Excellence in Consulting Award.
Sure. I mean, that speaks to a point that we didn't really get to, but is the fact that so much of expert work or pre-expert work happens within the confines of confidentiality. The only time things really become public is when you testify to them, as I understand it. And so I actually offered up 2 cases this time, and Jean-Pierre knows this is not the first time I've applied. So this is the second time I've applied, in part because for the reason that I think it's important for public historians to know about this type of work. And I think it flies perhaps largely under the radar. And so that was one of my goals, actually, was to try to get word out there amongst public historians that this type of work is valuable and is relevant. But the 2 cases were one on which I testified. So the first one was with the Confederated Salish and Kootenai tribes, involving this right-of-way that I think I mentioned earlier. There was a non-native land developer who wanted to develop a parcel of land next to a big chunk of tribal land that had been previously in a town site status. There was a map from 100 years ago where the federal government had suggested the possibility of building a road that was never built. And the non-native developer, took it upon themselves to go ahead and get their bulldozer out and begin bulldozing a road across the tribe's land without talking to them. And the tribe said, wait a second, we have a problem here. And I ended up submitting a report testifying in deposition, and then the tribe actually won on summary judgment, so there wasn't a trial in that case. And then the second case that I offered up was the case that I worked on with Richard, involving the Coeur d'Alene tribe's water rights within the context of the Coeur d'Alene Spokane River Basin adjudication. And I don't know if your reports were, I assume your reports were also submitted in the court proceedings, but DOJ submitted mine. I think yours were too, Richard. But those reports, I actually didn't testify in that case, but my reports were submitted with an affidavit into the court proceedings. So they're theoretically public if anybody ever took, wanted to go into the bowels of the court's documents. So those are the two cases. And in order to put forth my application, I went to the attorneys with whom I worked and asked them if they would be willing to submit letters of recommendation. And they did. And apparently they were sufficiently helpful or good that the committee awarded the award. So, and I think I might have gone over in my.
No, that's okay. But we are at the end of our allotted time, and I want to thank all of the panelists for sharing their expertise with everyone. And I want to encourage anybody who has additional questions to follow up individually with the panelists. There's certainly lots more to say about this. I'm going to ask the panelists to just stay on for a minute after we end here, because I'd like to get a screenshot where all of us look like we are, normal people. I've tried to do it a couple of times during the session, and one or the other of us has an expression that I'm sure you wouldn't want publicized. So just hang out here for a minute, and I will do that with everybody smiling and looking like they're having a great time. So thank you everybody for attending this session. We really appreciate it and hope it's been beneficial.
Thank you, everyone.
Thanks.
All right.